liability and the issues that he's seen and faced in Canada specifically. Next, we have Smita. Smita is an associate director at the Center for Communication and Governance at the National Law University, Delhi. She's formerly an in-house lawyer, and she's got tremendous experience in working in a law firm and working on the tech sector. Welcome, Smita. And then we have Madhukeshwar Desai. He is the Vice President of BJP Youth Wing, Delhi. Madhukeshwar is also part of the core committee that was selected by the BJP president, which is the ruling party, for the election committee formed by the president, Mr. Amit Shah. He was also named as the 50 most influential Indians by the GQ magazine of 2017. He's a lawyer by training, and he's also the CEO of the Mumbai Center for International Arbitration. Welcome, Madhu. Then we have Nikhil Pahwa. I'm sure a lot of you are familiar with the name Nikhil Pahwa if you ever followed the website Medianama. He's been one of the founders. He's the founder of Medianama. He's one of the pioneers in the tech policy sector, and he'll be giving his inputs on intermediary liability. Over to you, Saika.
Thanks. Can you hear me at the back? I'm usually quite loud, so that shouldn't be much of a problem. Thank you, and we are here to discuss intermediary liabilities. We are here to discuss the advent of fake news and what's it doing to societies and democracies across India, and where can people like you could come in and show us a direction on how to get out of this whole mess that we seem to be heading into, because I haven't seen anybody coming up with any clear answers. And it's interesting because several years ago, some of us were already beginning to see where this is going. And this was a time when everybody was getting pretty ecstatic about the Arab Spring and saying that this can bring changes to society which are extremely positive. But we could see that this was not exactly where this was going. And as Charles pointed out while we were having a quick discussion, a Canadian, and usually Canadians show where to head to the rest of the world. The Canadian, a man we consider a media guru called Marshall McLuhan, in the 60s wrote a book called Understanding Media, where, and this was a time even before television became so popular, and where he talks about how the speed at which information travels between those who are in government and the people they are governing, and vice versa, will have a huge impact on society. And today, in the age of the internet, as everything is at the click of a button, we see a much quicker response and a much quicker interaction, which on the face of it looks like a very good thing that has happened because it has flattened how information flows. It has changed hierarchies of information. It has changed how we look at democratization of news can take place. But at the same time, it's also created a lot of other problems. And those are extremely substantial problems. Just a few days ago, Vox, in light of what's been happening around these debates, wrote a whole piece on how social media is actually becoming extremely detrimental to democracies. Now, most of us who inherited and who live in a Westphalian world, we are looking at a situation where if we don't tackle these issues, there will be some fundamental challenges to the way we currently live. And that's what we are going to try and understand and debate. You've already heard, Nikhil has already introduced the panel, and I'll request if Charles could take off. I'll request each of my panelists to give a short 5-minute introduction to how they look at this problem, and then we'll get into a more detailed and more focused discussion. So Charles, if you could give us a more international experience of how some of you who have been in countries like the US and Canada, you've seen some of these technologies come from there. You've seen through the whole issue of privacy, data protection, etc. And also looked at how some of these companies have grown tremendously in terms of the power that they've acquired. Where do you think is this debate going?
Thank you very much. So I think we thought we understood what the critical issues were around social media. I think we thought that we understood the sophisticated business model that was developing, that was transforming society. But I think, certainly I think most people were just shocked by by Cambridge Analytica, and that it turned the debate about the role that internet intermediaries are playing in society. I think we're being forced to mature in our approach to treating internet intermediaries in much the same way I liken it, perhaps in my own self, as a child who's evolving and starts with a very sort of clear moral view of they're good guys and bad guys, and it's all simple, into a world where actually it's very murky and there's a lot of shades of gray. And how do you address these issues there's no simple answer. We have to find the right balance in protecting freedom of expression, but finding a reasonable, valid way to regulate the internet intermediaries. And so as the internet has evolved, so too has the role that internet intermediaries play. They initially, early on, the debate was quite simple, and it was simply a question of, well, are these intermediaries mere conduits of the content that flows over their network, or are they more like publishers, in which case they should be responsible for the content that's expressed on their networks? And it was a fairly simple debate. Now we see that, in fact, internet intermediaries play a multiplicity of roles, and there's a whole spectrum of levels of intervention that they play, and a whole spectrum of therefore their responsibility and the intensity of their responsibility. One of the roles that they are playing, and that we're learning more and more about these days, is the role of the attention merchant. We already understood that the currency of social media is personal data. We understood it as a pure business transaction. I'll give you my personal data, I get a free service. That's fine. But what we're realizing is that it's not just your personal data that they want, it's your attention. And in order to get your attention, the content that they are delivering to us through their algorithms is designed to keep us attentive. And there's much more attention to, is it keeping our attention, rather than is what material they are providing to us true, accurate, valid, or valuable. And so where internet intermediaries were once seen, I think, as a sort of there was an idealistic view of they're beacons of light. They're bringing sources of education and information to the people. They're providing opportunities for self-expression. They're pro-democracy. All of a sudden, with Cambridge Analytica and with the impact in Brazil and elsewhere around the world, there's a whole, the flip side has appeared before us. And I think going forward from a regulatory perspective, we have to realize they're neither beacons of light nor promoters of authoritarianism. They are neither and both, and we have to find the right balance in a regulatory framework. So I think going forward, a regulatory framework, properly constructed, has to be based on an understanding of the multiplicity of roles that internet intermediaries have, and be adjusted according to the various roles they play. The intensity of the regulatory burden is going to be varied on the basis of certain intermediaries have very strong market power and have therefore the resources to respond to the questions that are required to be addressed in more or less ways. But fundamentally, the regulatory solutions must always be based on finding the right balance in preserving the fundamental human rights that we must preserve and must be the cornerstone. Freedom of expression, freedom against non-discrimination, and the right to privacy, and finding the right balance between those and other fundamental rights.
Thank you, Charles. Are there any participants from China in this hall? Anybody from China? So it's not exactly a very global kind of an audience. And I just want to bring that in because while we think of these terms in technology and mostly in Western terms, there is a rising sort of group of people who, and a civilization which is also producing a lot of technology, which is now expanding vastly. And they look at the world very, very differently than some of us in this room. So with that in mind, Smita, if you could come in, and just to give a background, those from India who are familiar with it, in 2015 we had a seminal judgment from the Supreme Court called the Shreya Singhal judgment, which sort of set the cornerstone on how Indian law looks at intermediary liabilities. So Smita, if you could give a little bit of that, and also look at what the government is currently trying to do in India. And why I would like to bring your attention to this debate is because a lot of things that you saw in the American elections had already happened in the elections in India in 2014. But the world and the globe and the media was not looking at the elections as closely. Had they seen it, in many ways, a lot of those things that you're facing now had already happened in 2014, including issues of fake news and the weaponization of big data and stuff like that. So, Smita, if you could give us, in your opening remarks, a basic understanding of what the Shreya Singhal judgment did and what the government is trying to do currently.
Sure, thanks, Sekar. So just taking off from what Charles said, I do agree that we've seen a shift in the conversation about how to regulate intermediaries and whether in India as well as abroad in the past 8 to 10 years. When initially we were looking at regulation in India, the conversation was about how to identify and how to attribute liability for content and speech online. It wasn't about the impact of the speech or the content that we were seeing online, just about liability. And this conversation, in this context, it was pretty simple to formulate regulations. The individuals or organizations who were responsible for creating the content were responsible and liable for any impact of the content. And the platforms and other intermediaries that enabled communication of this content were not. So safe harbors were the norm across the world, and India also followed suit and provided a safe harbor under the Information Technology Act. What was a little more problematic, though, was the rules that they introduced, which kind of regulated what intermediaries should and should not be doing in order to qualify for this safe harbor. These were guised as due diligence that required intermediaries to put in place certain terms and conditions that their users needed to follow. And there was also some uncertainty about when intermediaries needed to take down content. Then in 2015, as Sekar mentioned, we had the Shreya Singhal judgment, which has been seminal for many free speech issues in this country. And one of the things that the judgment did was to quell some of that uncertainty that intermediaries faced in terms of when they needed to take down content. Now they only had to take down content when directed to do so by the court or by a government agency. Therefore, clearly saying that it was up to the judiciary or to the government, in fact, to decide on when content was permissible or not, right? And this conversation we've seen has shifted dramatically in the past few years. Today, we're not talking about intermediary liability in the context of safe harbors. We're talking about platform and content regulation. And this means that we're looking at the impact of speech online, and we're trying to identify how to regulate this speech, not just to identify who's liable for it. And this is a huge shift in terms of how we look at laws, right? And we have to look back in this case at the core of these laws, which are not, in fact, to actually provide intermediaries and businesses safe harbor from liability, but do have a huge impact on our fundamental freedom of speech, as you mentioned, Charles. And in this context, we now have new laws in India, which proposed new laws, which move far beyond providing just a safe harbor and ask intermediaries to regulate the speech that's available on their platforms. And we have to remember in this context that intermediaries are, it's a very wide definition under the law. It's not just your social media platforms and communication platforms. It's every internet service provider, every telecom service provider that we're talking about. But the problem is that these proposed laws have been identified certain issues, such as misinformation, which is one of the biggest issues that we face with the way platforms function today, and have tried to apply regulation that will mitigate misinformation online to all intermediaries, right? And they have, in effect, delegated the determination of what kind of speech is illegal to the intermediaries, to the platforms themselves, who will now be required possibly to proactively monitor content and take down content. Again, this goes back to the fundamental freedoms that we have under the Constitution. We have to remember in this context that in India especially, and in several other countries, the concept of what is illegal speech has already been subject to law as well as decision-making by courts. We have a long history in India of saying that there are certain very limited permissible restrictions that, on freedom of speech and expression, and these restrictions can be applied only in a reasonable manner by law. The idea of delegating the decision-making of how you identify what these restrictions are, how you identify what is illegal speech, basically contravenes these constitutional rights that we have. And while I think everybody in this room will agree that misinformation is a problem, that the way platforms are allowing us to communicate information has caused lots of problems with democracies across the world. It's also, closer to home, caused actual physical violence and death. In India, in fact, last year there were 30 or odd deaths reported that were attributable to the spread of misinformation online. But the problem is that if you look at it from a freedom of speech perspective, right, and that is the core fundamental right that we do have that enables us to exercise all of our fundamental rights under the Constitution. Misinformation is not illegal speech in itself, right? Fake news can be illegal speech when it's used to undermine public order, to undermine national security, to incite violence. And this is what has been established by the courts over the past 70 years in India. So identifying this problem is one thing, but what we need to do now is see how to solve for it. We need to identify what we're trying to solve by changing intermediary liability rules, whether we're just changing how intermediaries themselves are liable for content that's posted online, or whether we're actually regulating and restricting freedom of speech and expression of all of the individuals in this country and across the world that use these intermediaries.
So I'll just put you on the little bit of a spot and ask you two questions. One is that all this that the government is doing, in your view, as somebody who's not just been a lawyer, but also somebody who's looked at communication and the impact of communication, what is the end game that the government is? And if we can extrapolate and see what other countries and other governments are doing, what, according to you, is the government's end game in what they're trying to do?
I think, Sekha, the problem is that this is something that has not been articulated very well.
That's why I'm asking you to guess.
And we've had this conversation in several fora before. So what we are trying to do is put an end to the violence or to these negative consequences.
When you say we, is it you as a lawyer, or are you saying we as a country?
I would say that we as a society
No, but I'm asking you, what is the government trying to do? What do you think is the government trying to do?
I do think that that's what they're trying to regulate.
That is, regulate the
consequences of the misinformation. If you look at other governments, they have put in more narrow restrictions on terrorist content, for instance, in the EU. So I think the problem is that we are not identifying these issues in a narrow enough manner. We have just said that we need to do something about this widespread problem.
So you think there is an honorable intent in what the government is trying to do?
I would hope so.
Yes. No, I'm not asking you to hope.
Yeah.
I'm asking you to guess.
I do think so, yes.
You think yes. Are they also trying to regulate free speech in some ways, or are they ending up doing that because the implications of what they're trying to do is a regulation of free speech? Do you think that's happening?
I think that the implication is that it would regulate free speech in some ways, because most importantly, we are creating new categories of illegal speech by formulating these laws. And this is not necessarily a new problem in terms of the draft regulation that has been proposed in the past couple of months, but it has been a problem with the way the intermediary rules in India have function. And many researchers and civil society organizations have pointed this out from 2011 when the rules came into effect.
What you just said, that they're trying to create new categories of illegal speech. So is that because the government is not being able to understand technology, or is it because the law is limited and therefore we are grappling with this?
I think the law is limited, and also we're trying to identify how to apply and, more importantly, enforce existing laws in an online space, right? The laws that we have that regulate speech, that identify illegal speech, are under our criminal laws. They're under the Indian Penal Code, they're under the criminal procedure laws, and then there are specific, narrower laws that apply in certain situations. There are laws that apply in the case of elections. So we did a report on hate speech laws in India last year, that we published last year, and we found that there were laws under the Customs Act that affected speech, right? So it's quite widespread. The problem is how you regulate this and how you find the speech to begin with online, because it's so vast. The traditional forms of communication are no longer what you're dealing with. You're dealing with thousands and millions of people online and saying things in a way that it's not possible for the government to track. And then how to also, more importantly, I think, find the ways in which the speech relates to the consequences. Because if you look at illegal speech, a lot of why speech is illegal is because of the consequences. And you have to be able to prove, for instance, if you're talking about harmful speech, that there was incitement to violence or there was intention to do something that's illegal, right? And given the way communications work today, given the fact that you can send a message to hundreds of people on a WhatsApp group and nobody will know where that message is coming from, but that message has clearly caused violence, as we've seen in India with the 30 deaths. It's a question of how to regulate. And I think that's something everybody is grappling with. No, there are no solutions right now.
Thank you very much for that. And we'll flip the order a little bit. Just a quick disclosure. You get to see there are 4 people here, but there are actually 5 people. And that's because there are 2 of Madhukesh here. One as a politician and one as a lawyer. So that's why you've kept an extra chair, so that he can switch chairs. Because I'll come at you with some questions to both of you, the politician and the lawyer. So you just keep switching chairs and hats as I ask you these questions. And the reason I asked you, I put Smita in a little bit of a spot, was basically to see, and she very politely had a guess of what she thinks the government is trying to do. And you also have certain thoughts about this. So if you could speak a little bit about your thoughts. And I'm also, again, another disclosure, I'm making you go first because you have Nikhil power. All you need to do is provoke Nikhil power and then you see fireworks. So I hope you will provoke Nikhil power.
I'm already ready to disagree with Smita and give him more to respond to.
Exactly. So if you could think of, what do you think the government is trying to do? And also come in at how do you look at this, how social media has emerged, and your party did a fantastic job in 2014 of using this. And what do you see is going to change, or do you want to see any of this change?
I'll clarify first and thank you for that. I'm not a domain expert in this field. My party has used, and my government continues to use, can you hear me? Is the mic on?
It's on, but if you could speak a little louder. He's a rare politician who's extremely soft-spoken. So.
I'm also one that said that I like nuance, if you remember in the last one. My government, our government and my party, from 2014 and earlier, and even now, has used social media very effectively. And full disclosure, I'm actually currently on the Lok Sabha Core Committee for social media to strategize for the party's upcoming elections. The way I look at it, now that we have the 10-year challenge hashtag that's going on social media, and if you see, we sort of flip that and use that for the party and government as well, to give you an idea of how switched on we are with the use of social media. With the 10-year challenge, if you look at 2009, touch upon what Charles said, it was sort of the savior of all things bad in the world. With the Arab Springs, it sort of said that, we're bringing in democratization into places that didn't see democracy and would probably never see it ever. It was giving a voice to people that never had voices before. And it was being seen as, cutting out the middleman and giving a voice to people and actually getting authorities to listen to them. 10 years later, we're sort of in a different place. And I'm going to use a word that, of course, Saika disagrees with me with. We're in a place where these intermediaries or these platforms, to my mind, are large non-state actors that have tremendous amount of influence and are sort of omnipresent now. And they're no longer a tool that is just used by people to sort of voice their concerns, but they are sort of using us as a tool to benefit themselves.
When you say us, do you mean BJP or the lawyer or the citizen?
Citizen.
Right.
So I'd say everyone in this room, right? So like Charles said, first it was just your personal information, now it's your attention. And I think that's very important because the stuff you get online, pardon my French, is crap, but it gets your attention.
That's not French, by the way.
You work by this policy, and a lot of social media uses as well, is you'd rather be entertained than educated. And unfortunately, the quality of entertainment has significantly reduced, but your attention span has significantly increased for that. Coming to the more pressing issue with organizations like Cambridge Analytica, it's very worrying with the political hat, of course, that you have a state-sponsored private organization that is using a platform to influence elections, or that can exercise that much power and influence that you can circumvent a state. So that is something that is extremely concerning. The other thing that is extremely concerning to me personally, while for a lot of people sitting on the stage and in the room, the number of people that have passed away because of lynchings or people that are affected because of violence, because of fake news, or because of false news is a number that you read about and probably feel bad about for a second. But I don't think anyone over here, probably besides me, I'm making an assumption, has met someone who's actually been affected because of it.
Sorry?
Has been affected because of fake news, right? I'll explain a little more. When you come to WhatsApp, the number of WhatsApp forwards that you get, on my phone I must have 300 groups probably, with continuous WhatsApp forwards that keep coming. And it's an admission of, to my mind, the fact that WhatsApp and platforms such as WhatsApp understand that they're playing an important role in spreading this misinformation or fake news. The fact that they've taken steps to limit the number of forwards that you can put forward, the number of groups that you can create, and mark up on top the fact that it is a forward. To my mind, that is an admission of the platform, and they understand the fact that they do have some amount of liability when it comes to the spread of fake news. Nikhil clearly disagrees already. So coming to the point that I was making before, with the spread of this, coming to the government's intent, when you look at the effect of social media and the way that citizens are being used by it, as opposed to the other way around, it's important that safeguards are put into place. And I think that is the primary intent behind this, as opposed to some sort of big brother perspective or a Chinese perspective of let's look at everything that you have and control everything that you have and make sure that we have all the information.
So you said that safeguards to be put in, but let's say you mentioned Cambridge Analytica, and I think you were the first one to mention Cambridge Analytica on this. I was just joking. So you mentioned Cambridge Analytica, but my point is, who was using Cambridge Analytica? So do we stop at Cambridge Analytica, or do we go beyond Cambridge Analytica and look who was using it? And if we look at it, they were trying to influence a certain political outcome. But every political party wants to influence a political outcome and would probably use the same means. Today, is it very different? I mean, today the Russians allegedly used Cambridge Analytica to influence the American elections. But if your party today, or the Congress party, or any other party, were to use the same tools to influence a political outcome, is it still as bad, or just because you're in the same country, is it good? That's my first question. Two, And I'm going to put you a little bit of a spot
So before
here.
you put me in the spot, I'll answer that question. No, I think it's bad.
It's bad. Is anybody recording this? We need this in a few months. Two. You're on Facebook Live. Excellent. And you had to choose Facebook for this. Two, let's say fake news is aiding a certain political narrative. Like, for example, we've seen in the American elections, there was a lot of polarization. We are beginning to see a lot of polarization here, and fake news and disinformation and misinformation, including going back to the first prime minister of this country, a lot of fake news, etc., and coming from very responsible people in certain political parties, we'll not name who, are actually putting some of them even have apps which are putting out a lot of this fake information. So what, if it is aiding you, why would anybody in power want to regulate this aspect?
Because we're not dictators. Right? We believe, the party believes in a certain democratic process, the party believes in the constitution and believes that there should be certain rules by which you play. And I'll sidestep and come back to this chair for the political side for 1 second. There's this question about EVM tampering that happens all the time. Every time an opposition party claims that EVM tampering happened or there was an issue with the EVM, but then they win an election and then they say everything is fine. So, the point that
but
the simple point.
Really fake news or misinformation.
The simple point.
Fake news and misinformation is when you have an app which is collecting a whole lot of data, which is a political app in the name of a prominent political leader, collecting a whole lot of data.
Sidestepping everything.
They're collecting a lot of data, and they're also using that as a HuffPost piece, as recently pointed out, is also a means for spreading a whole lot of fake news.
So, I would like to correct you with one thing. If you use the app that you're mentioning.
I didn't mention any app, did I?
You just said an app. So if you use the app that you're mentioning and the HuffPost, I don't think they've actually looked at the app properly, because effectively the point that they're looking at is it also has a platform like Twitter and Facebook where anyone can come and post something,
it's now become an intermediary, right? It's now an intermediary. So what do you do with that intermediary as well?
It would fall under the same rules, right?
Right.
So you can crucify me today if I say that that should not be under this definition. But I'm not saying that. And if you, and I would like to stress that it's draft rules. If you see the draft rules, they effectively say 50 lakh users. And that application definitely has more than 50 lakh users. So it would fall under that definition.
Right.
So technically you would be regulating free speech, or would be not allowing free speech of individuals from my party.
But
so
what Smith also said, that you also look at the expansion is leading to criminalizing a lot of aspects of free speech which are frankly not even criminalized or barred or
so I don't think the rules create for any new offenses. I may be wrong here, but I don't think they create any new offenses, right? The offenses are already in statutes that exist. Correct me if I'm wrong, please.
So Nikhil, you've heard Smita, you already have some disagreements, and I guess Madhu has just added a little more. All yours.
Look, so I'm just going to go back to the point about that the intention of the government. So by what Smita was saying, it is almost as if the intention of the government to bring these rules about for making changes to intermediary liability protections is new. It's not. If you remember, even with the last government, they were arguing against making safe harbor safer in the Supreme Court during the Shreya Singhal case. When the government changed, and let's not forget the BJP, which is currently in power, had opposed the rules that opposed 66A, and the case continued after they came into power, and then still the government lawyers were in court arguing for 66A to remain constitutional and for it to be retained, as well as against the dilution. So governments,
a political party comes to power, they speak the same language.
Governments come and governments go, policies remain pretty much the same. The direction is very clear. If you remember, even post that, there was a report, I don't quite recall which one, but there was an MHA report which also said that 66A should be brought back. Right.
For the international audience, MHA stands for
the Ministry of Home Affairs,
which is the interior ministry which regulates law and order in this country.
So the intention to dilute safe harbor has been there, and what fake news has done is merely given it an impetus, a reason to do this. But let's just set fake news aside, because the changes to intermediary liabilities don't just affect content, they also affect services, they affect payment gateways. If you look at the 50 lakh or rather 5 million users definition that's come about in these rules, that impacts pretty much every single ad network in the world. So the scope of impact of these rules is substantive. And if these rules are being brought about merely for the objective of regulating fake news, then they're extremely myopic and in the outlook, and frankly blind in their impact, in terms of the impact it's going to have. So these rules, the way they've come out, they need to be scrapped. What that leads us to is the categorization debate about whether certain types of intermediaries should be regulated differently from the others. And for that, let's look at it from a global perspective about where we were and where we are today. Because you started this discussion looking at, back in 2012, 13, etc., we weren't looking at Facebook as that much of a problem. We weren't looking at Google. What happened in 2007 after the iPhone came about was a fundamental shift in how users access the internet. India adds about 60 million internet users every year, and for most of them, they do not know how to type a URL. They download an app, they use the app, right? So the web versus app battle that there was a debate going on in 2008, 2009, that's been won by apps. Now, what does the shift to the app ecosystem for the internet portend? It means that there's a concentration of power. If you look at just yesterday and today's news about Apple versus Facebook over privacy issues, where they were effectively circumventing Apple's privacy guidelines to and giving kids $20 to route a month to route all of their traffic through a VPN. Look at this battle that's happening here right now, right? It's Apple's policies governing Facebook here. In the same way, in the Google Play Store, if you go back to about 6 months ago, they took down the UC browser app. It's Google's policies governing the UC browser. So what you're seeing with the internet right now is a significant concentration of power in the hands of a few intermediaries, which you would normally look at it as Google, Apple, Microsoft, Facebook, Amazon, Tencent, Alibaba, Baidu, now TikTok, Snapchat. Anything with over 1 billion users accumulates significant power. So fake news has become a relevant issue today. And I mean, about 2 years ago, you raised this issue that fake news is not new. But the difference is the concentration of fake news and the concentration of audience. So from that, there's a fundamental shift that's taken place there, in which case it's also become a privacy concern. There's a concentration of user data. So every single major policy issue that we are seeing today can be, you can sort of drill it down to the issue of centralization versus decentralization of the internet. So when you're looking at regulating intermediaries, you're effectively, the primary narrative that's coming through is regulation of significant intermediaries. Now, how do you define significant intermediaries is that question's coming through. The Indian government's defining it as about 5 million users in India, even though I'm not sure how they can define whether these are Indian users, Indian citizens, people who are using it from India, what about people who are using VPNs? The definitional problem is a big one here. What this categorization does, so this categorization or this trying to attempt to regulate significant intermediaries like it's been done in case of Germany as well, is essentially an attempt to at some level to decentralize or make someone responsible for the decentralization. The solution to centralization is effectively decentralization. We don't yet have an answer to what that solution is. So, just to complete my thought, right? The question that we have to answer about amending intermediary liability protections is, does it lead to the decentralization of the internet? Does it lead to the user data being spread across multiple intermediaries instead of being concentrated in the hands of a few? Does it lead to fake news then being spread across instead of it going through certain platforms? And what does regulation do? Does it end up strengthening those intermediaries and creating a barrier to entry for competition? For example, if there were stronger intermediary liability regulations in place, would a TikTok have emerged or not? or do we end up strengthening these intermediaries now, right? So if you even look at some of the moves that traditional media organizations are making in terms of the power that they're losing because of a more user-generated world today, they are attempting to create a categorization difference. Let's take the OTT code that has come out from a bunch of companies, including Star, which is owned by Disney, and Netflix, and a bunch of others, saying that they are curated content providers rather than user-generated content providers. They're trying to create a distinction for regulation between themselves and YouTube, so that more stringent regulations are applicable on YouTube at some level, and that sort of gives them a hope in a user-generated world.
Although from a libel perspective, usually those who are curating and creating content have higher standards of responsibility than, I mean, as journalists, we always face that.
Intermediary liability is a tool in this, the attack on SAFA is a tool in this battle. And let's take even if you look at the things from a privacy perspective, that's also a tool in this battle. So, you know, what we have to look at here is, what are we trying to achieve with this? Are we trying to, if you're looking from an impact perspective, like whether people are getting killed because there's concentration of fake news on one platform, are we trying to address the impact without understanding how it's going to then, how it's going to affect the fundamentals of the functioning of the internet? Because what the internet is essentially about is taking audio, video, text, and interactivity, remixing them in completely new ways, which is what has brought us the innovation that it has. It has allowed people like you and me to participate in this, in content creation and communication and mixing of all of this. So if you start categorizing intermediaries, if you start having sectoral rules for sectoral intermediaries, you effectively convert the internet into what the old world used to be, where there's greater amount of control for governments, but there's less freedom for people like us.
You said something very significant which I want to bring you, that today we are seeing a significant, and Charles, I want you to also come into this after Nikhil. Yeah. You're seeing a significant amount of power concentrating with a few entities, shall we say. And this is happening because that's the nature of the free market. I mean, whoever comes up with the most disruptive technology or innovative technology which appeals to a mass of people, obviously capital starts moving towards that technology, which leads to greater acquisition of numbers and therefore accumulation of power. So that's how the free market...
It's also about abuse of power.
Let me just finish my question. So that is what is happening. So in a way, countries which are not producers of the internet, like India is not a significant producer of the internet, it's a significant consumer of the internet. Whereas companies from the US, Canada, China, UK are today major producers of the internet, and they are producing technologies which is accumulating a lot of power. So how do we now, from a point of view of law, how do we really address this? Is this something that we look at breaking up these companies like antitrust laws, or how do you regulate this power?
So, look, there are there's the school of thought that antitrust needs to be, and I'm not a lawyer, so pardon me if I get something wrong. There's a school of thought that antitrust needs to be looked at again, because it relies on two pegs. One is market dominance, and then the second is the abuse of market dominance. There is a thought process that says that you need to start looking at market concentration, and if there is some sort of concentration with large players that has happened, that is therefore reducing the participation of new players in that market. Yeah. So that's one way of looking at it. I don't have an answer to this problem of decentralization, but I am thinking about it. I'm looking for a solution there, because for me the solution to this problem lies in decentralization, not in regulation that will further encourage centralization of power.
So I'll come to you with the same question, Charles, and add just one more layer to it. We've seen a significant amount of changes, and for a minute, let's forget Cambridge Analytica. But look at what happened in Myanmar, where the United Nations says that Facebook was used for helping out a genocide, where the generals and their henchmen used as a state, and that's where I was coming in, that it's not just a non-state thing. Behind non-state actors, there are states. So we have to recognize those states. In Myanmar, the government used Facebook, and the UN recognizes this, to carry out a genocide. So essentially, it's boiling down to how it's all about power, and how do we globally, as a global community, which is discussing a global norm, which is a global common like the internet, how do we regulate this concentration of power vis-a-vis also allowing space for technology to do what it's supposed to do, because it also does a lot of wonderful things.
So a couple of comments. I thought it might be helpful just to provide some concrete efforts to address the question of market power that you were just describing. I think we should, in a sense, hive off the issue about incitation to violence. I think that's another issue that we want to cover, but if we could just focus on the issue of market concentration for a moment. I wanted to point to two elements that we've seen in Canada that could be of interest and relevance to this point. The first is the recognition, as I was saying, that the intensity of the obligations of certain internet intermediaries will vary depending on the power that they hold. And we saw a very interesting decision rendered by the Supreme Court of Canada and we were involved in the case, Google versus Equistec. And it wasn't about misinformation or false information, but it was about a situation where there was a company that was clearly violating trade secrets and intellectual property rights of a third-party company. And the illegal behavior was, company X. Google had nothing to do with what the illegal behavior was. And the sort of the victimized company whose IP was being abused would try to shut down websites where their trade secrets were being violated. And every time they did that, it was like whack-a-mole. They popped up somewhere else. And so every remedy that they seemed to have before the court of trying to stop this illegal behavior, clearly illegal behavior, it became impossible. So that they decided that the only remedy that they had was to go to the search engine and force the search engine to block access to this company that was acting illegally, wherever it stopped the search results that led to the illegal results. And they were successful at the Supreme Court of Canada. And what the Supreme Court said is that they said, Google's not liable for the harm, but Google has a determinative player in allowing the harm to occur. And on balance, the only effective way to mitigate or address the illegal behavior was to force Google to block the searches. So this went through an elaborate court process, and there were assessments of whether or not there were appropriate constraints and so on that were put in place. But ultimately, this Canadian Supreme Court decided that on a worldwide basis, Google, because of the role that it plays in society as a very specific, it has this unique role, really. On a globalized basis, it had to block certain content that was clearly illegal. So that's the first point. I think it is worthwhile saying certain players have such power and play such a role that even though they are not responsible for the illegal conduct, they have a role to play in blocking the illegal conduct. The second point that is there's recently been there's been a parliamentary committee that's specifically focused on the Cambridge Analytica case and
this is a Canadian parliament.
This is and the threat to democracy that's posed by that question and how to address it. And they talked about a lot of things, and they proposed some quite concrete and interesting solutions. But just to the point of revisiting competition law, I wanted to kind of comment on that. What they said, and it hasn't resulted in a change to law yet, but they said maybe we have to revisit competition law that is so focused on market dominance that results from the ability to, for instance, set prices in a non-competitive manner. Because it's not just about price setting. I mean, most of these service providers are offering free service, right? So it's about market dominance that comes from the ability to use the negative externalities of market power to set the debate. And in a context where, as I say, these internet intermediaries, some of them, are attention merchants, they have access through these apps and through the platforms to incredible detailed behavioral information about individuals. And they are therefore able to influence individual behavior, individual choices, and individual choices that have an impact on market dominance in very rare and specific ways. So I think it is important as we move forward, as we think through these issues, and there's no easy solutions, but to think about to think about whether we have to revisit some of the approaches to regulating market dominance and to bring in not just price issues, but the control over individual attention.
But here's the dilemma. I mean, here I'll put on my journalistic hat and
Please.
ask a provocative question. It's all about power, and it's also about money. And as they said during the Watergate investigation, follow the money. So if a big corporation has the big money and wants to set the debate in a certain manner, for example, let's say Facebook, in the Cambridge Analytica thing, it turned out that 500,000 Indians' data had also been accessed under Cambridge Analytica. The Minister of Information Technology went on Twitter and said, I'll drag them, I'll file police complaint against them, I'll ensure that they can't mess around with our data, etc. And suddenly became completely silent a few weeks later. And when under the Right to Information Act, when applications were filed asking them, what did you do about it? The government came back and said, look, this is third-party information, so we can't tell you what exactly has happened. So no Indian today really knows what happened to the data which Facebook had and which was accessed by Cambridge Analytica. So when you have a huge corporation with so much of power, or let's say any other company in history, the only solution or the only way to go after them is by using your government to try and regulate them. But the dilemma that the government also faces is that how far do we regulate them? Because we don't want to look anti-business either, because political parties get a lot of sustenance from the same corporations. But more importantly, if we shut down business, then that's a huge blow to the economy, and a whole lot of lawyers wouldn't get good briefs if that were to happen. So where do we find the middle ground here?
So let me, the questions to me?
Yeah.
So just again, to go back to some Canadian response to that question. It's very interesting, but almost 10 years ago, one of the very first really in-depth examinations of Facebook's practices about collecting personal information was carried out by the Privacy Commissioner of Canada. And at the time,
this was in which year?
I'll come back with the date, but it's whatever. The time is vague.
Yep.
It moves so quickly. But it was the Facebook decision. If you find the Facebook decision, Privacy Commissioner of Canada, you'll find it. At the time, people said, "Well, wait a minute, Facebook privacy. How can Facebook violate people's privacies? People are so ridiculous. They reveal the most revealing secrets of their. They look at me being stupid at a party, and I'm going to post it to the world." Sorry, folks. You just sort of lost your right to have some privacy, and that was the whole debate was around that. But the Privacy Commissioner of Canada actually looked at their practices, and some of them they said were fine, and they even said, this notion that personal information is currency and you're getting a free service and that's a bargain. They said that's legitimate. But Facebook at the time was doing 4 or 5 things that people didn't really understand and that they felt were shocking. And one of them was, and this is directly relevant to the Cambridge Analytica discussion, was all of those apps that you saw in the margins and you thought were just little fun games and distracting and isn't this fun, Facebook was giving free access to their entire database of personal information to thousands and thousands of third-party app developers so that they could, increase their market share. And at the time, that was shocking. That was shocking. And at the time, and it became illegal, by the way, after that. And Facebook was required, as a result of this original Facebook decision by the Privacy Commissioner of Canada, to change its practices worldwide and to introduce this notion that you can't, Facebook couldn't transfer the personal information on its users to third-party app providers without consent and without transparency. And yet, that is exactly what they did in the Cambridge Analytica. And in part, Cambridge Analytica was using data that they had collected prior to this decision, and they just extrapolated because they had all this rich data. So the fundamental principle there was about accountability, and that's a cornerstone of privacy law, was that you are ultimately responsible for the processing of personal information, even when it's in the hands of a third-party processor. So in other words, Facebook had to not only not permit the transfer of personal information to those third-party app providers without consent and transparency, but once it was in their hands, they were accountable for assessing whether it was being used appropriately in accordance with the terms. And that's where, again, they failed, right? So I think part of the role in solving this issue...
And this was used under the aegis of privacy laws?
Yes, privacy laws. Yeah. And under Canadian law, the first principle of privacy law is accountability. Okay. So there's second or third is transparency and consent, but the first is accountability. And so, in the Cambridge Analytica scenario, one of the issues was once the data was in Cambridge Analytica's hands, Facebook did nothing about auditing whether they were compliant, or they paid no attention to how that data was subsequently being used.
Madhukesh, you had a view on this.
So more than a view, I just wanted to give a perspective. You're a journalist, of course. You have a editorial process before you publish something in your newspaper or publish something online. With TVs or with ads that run, there's a certain regulatory process that exists. Both these sectors haven't really dwindled with their influence or their size beyond a point, despite the fact that there is regulation in this sector. From a government perspective, as well as from a lawyer's perspective, making policy for anything to do with the internet or something new becomes very challenging because the legislative process in itself is very slow. If I can take just 1 minute to just explain this further, the first airplane was invented in 1903. It took a significant number of plane crashes, hijacks, significant other issues for it to be regulated well enough to a point that we are in today. The first drone, Parrot made the first drone, right, which was used by consumers in 2012 or 13. I bought one of them. You have more number of drones today than you do the number of commercial aircrafts flying around in the skies. From a policy perspective, the next decision, and not just in the Indian context, but globally as well, you move towards a place of let's just ban it because your top priority is safety of citizens. So coming to the context of what we're speaking today, you see knee-jerk reactions of cutting off the internet when there's violence in pockets. That is something that no state, no government wants to do.
They don't want to do
that
what?
Cut off the internet as a knee-jerk reaction. Shut down services as a knee-jerk reaction. Whatever. So internet today is a service, just like electricity, water, and so on. So that is something that no state would want to do. So in the context of other industries and sectors that do publish information and do protect free speech as well, that are regulated, are still flourishing. I just thought that we could look at that in this context as well of this debate.
Smita, I'll ask you 3 questions. One he's already covered. So basically, where and what is the role of transparency? how transparent do we want, of course, the government to be when they're dealing with these intermediaries, but how transparent do you want the intermediary to be? Two, what is the role of consent in this, and is consent really broken? I mean, Rahul Mathan for years has been saying consent is fundamentally broken. I and Nikhil don't believe that is so, but where does consent play? And three, my final question, you are in a situation that somebody has to be the arbiter. Government says, look, we'll be the arbiter. We all stand up and say, hey, you can't be, because if you're too big an arbiter, you will restrict my freedom of speech. But then, do we want the intermediary to be the arbiter? Because then they don't want to get into too much of litigation. So even before a challenge could rise up, the first thing they'll do is they won't protect free speech, they'll just remove content, because that's the safest way to take. So in this debate, where does the balance of power ideally lie? So 3 points to this. Where is consent? How transparent? And where does this power for arbitration lie?
Sure. So just to the first question on transparency, second, right? I think it's one of the key principles of any data protection and privacy law, but it should also just generally be one of the key principles of the way business is undertaken, especially in this context of internet platforms where so much of our communication today is done on these platforms, where it's become an essential part of our lives. And we've seen that whether because of legal requirements or otherwise, a lot of the bigger platforms are starting to put out increasingly detailed transparency reports on the kind of data requests that they get, the kind of data that they take down. And I think that's just definitely a good, positive step, and that there should be more in this direction.
And should that be enforced by government laws, by policies, that transparency?
I would say to some extent, yes. So if we are going to have a new data protection law in India, I think that transparency should be one of the key principles that is built into the way the data protection law regulates companies, right? And also governments, anybody who's collecting or using data, basically. And I think that is one of the key principles that many countries follow. Yeah. And coming to consent, I agree with both. The idea that, well, I do in the sense that, look, consent is not enough anymore. I don't know if it ever was, but it's definitely not enough anymore. It's no longer because of the very convoluted ways in which people can use data, that it is almost impossible for anybody to understand, even those of us who work on this and like make our living off of these kind of jobs. I think that consent is very important because it closes the notice loop. It makes sure that you have notice of the fact that you have your data is being collected and used in a certain way. It informs people that this is what is happening with their data, and it also, to the extent that you are able to understand and understand what is happening with your data, you're able to make that decision. It's not that we don't understand anything of how our data is used. There are some things that you can agree to, some things that you would disagree to. So when you download an app, those of us who are particularly aware of this would look at the permissions that are taken and then decide whether or not we want to use it, to the extent that we have the option of doing so, right? So it is important, but it's not enough. So you need to have consent plus accountability plus transparency plus the many other things that a data protection law provides for. And I think that's the key, that the combination of those principles is what is important to get right. And sorry, your third question
point was the arbitration. Who gets to be the arbitrator?
That's really interesting. So actually, just last night, I think Daphne Keller published a paper on who to sue, the government or the platform or the intermediary. And I think...
And sometimes they use one to sue the other,
yeah.
actually.
I think that that's the problem, that's one of the big problems with the proposed intermediary rules that we do have, that a lot of the powers of the government are delegated to intermediaries. And the thing is that even though the rules weren't perfect before, we knew that there was a much more reasonable chance that if content was being taken down, it would be taken down at the behest of a court order, right? Today, that's no longer the case because there's proactive monitoring by the companies. If these rules come in, they are draft rules, if these rules come into effect, then there is proactive monitoring by the intermediaries. And the rules do not provide for any process to be followed beyond proactive monitoring, right? There is no natural justice principles that are incorporated. So there is no, if you are going to go this way, there needs to be some process in terms of notifying the individual that their content has been taken down, giving them an explanation as to why. No, it's not really built into this process.
Caravan, it's a long-form magazine in India, has just published a piece where they're alleging that because the government, the BJP is in power, anything which is anti-BJP or anti-government, Facebook immediately takes off, and they have got a whole lot of anecdotal evidence, not empirical, but anecdotal evidence to make that point. And Facebook is very happily doing that because they don't want to get into trouble. As any private corporation, they wouldn't want to get into trouble. So do you think that's the way to go? Because those dangers are also there. The lack of process is also leading to, people still manipulating these intermediaries without actually, and the fact that there is no process is actually helping them.
Yeah, definitely. I don't think, currently under the intermediary rules, there is no process specifically that's designed. There are processes of notice in other rules under the Information Technology Act, but even those have been criticized quite a bit. I don't necessarily agree that this kind of proactive monitoring and delegation of this responsibility is the right way to do it in the first place.
You don't agree.
But if we are going to have some responsibility on the intermediaries or the government for that matter, if any content is being taken down, I think that whoever's posting that content should be notified and should have the opportunity to question that decision, whoever is making the decision. I think that there has to be some sort of process built in.
Nikhil, like you and like me.
So frankly, I think we're conflating a bunch of issues. So misinformation, privacy, and this is all coming, we're trying to hold intermediaries responsible for it because it happens through them. They're effectively a function of their own, they're victims of their own success in that sense because they've been able to achieve that scale. They've gotten that scale because they've had protection under safe harbor, and at times, and there is a significant gap in terms of the responsibility and the accountability of intermediaries. What law is now trying to address is that gap, right? And it's not to say that upon having actual knowledge of misuse of the platforms, the intermediaries should not act, they should. And I think that's what also the law requires them to do. We have to also look at what we stand to lose if safe harbor goes for them, or if it is diluted significantly.
When you say we, are you talking?
We as in people who use it, users who use it, because the direct impact is going to be on us, on our free speech. The protection of the carriers and the conduits of free speech is just as important as the protection of speech itself, because without them, we would not have that avenue to speak and to be heard. There is misuse of the platforms, and therefore the people who are misusing the platforms need to be held accountable, which is where the other orthogonal issue sort of comes in of traceability. And I don't think we have enough time to discuss traceability here, but let's not forget that the issue is coming from the fact that it's difficult for governments to identify who's creating a problem, and therefore they're now going after the intermediaries which are being used to create that problem. And we need to actually, my belief is we need to protect the intermediaries because we get hurt in the process as users if they get hurt in the process. That is not to take away from the need for there to be a greater competition, for there to be more intermediaries in play, for there to be opportunities for other intermediaries to become larger.
You're saying to protect us, we need to protect the intermediaries.
Absolutely, because it's effectively what was happening in 2011, 12, 13, right?
But the world's changed since 20.
The world has changed, and that's because of the protections. But our speech will get hindered because the takedowns that will happen, because no single intermediary in this world will survive the liability of the way users use them in this format. No ad network will survive the liability of, they serve billions of ads which are modified by algorithms where the text of the ad can be changed, the color can be changed. All of that's happening in an automated manner today, right? Ad networks are serving billions of impressions across billions of pages, which they have no control over the content. The moment they become liable for where that ad is served, the entire online advertising industry is going to collapse. So let's not forget that the intermediaries enable good behavior as well, and do we really want to risk the usefulness that they bring, the ability that they bring for free speech? Do we want to risk that because of incidents which are important to address, but which can also be addressed in other manners, like holding people accountable for their actions when they are caught, right?
So, Madhukesh, since we are running out of time and I want to give a little bit of time for question answers, if I were to give you three choices which are fundamental to this debate: surveillance, free speech, business, which one would you choose if you were to wear all three hats?
Surveillance, free speech, and business.
Business.
Freedom to do business.
I think they're all on the same platform.
You can only make one choice. Choose one.
There's no right answer. There's no blue pill and red pill.
You have to choose one before I go. Choose one. I mean, just play wild. I mean, nobody's recording this. This is not Facebook.
It's actually playing on Facebook right now.
So you wouldn't make a choice?
With those three, no, I wouldn't make a choice. I couldn't choose one over the other.
Which also, incidentally, is an answer. Not taking a decision or not making a choice is also, I think you're in trouble. But having said that, any questions, any very short comments? And if you could also introduce yourself.
The mic.
If you could come to the mic and...
Hi, Amit Jaju, FTI Consulting. You made a very important point about,
you being...
Who?
Sorry?
Nikhil.
Nikhil.
Nikhil, you made a point that being responsible and the fear of not getting caught. Now, when it comes to intermediaries, the important thing about anonymity is crucial here, right? We talk about privacy, we talk about responsibility of fake news. Now, there has been a lot of developments in the tech world where now we are talking about IPv6, where every grain of sand now can have an IP address. Whereas with emails coming in, WhatsApp messages, we don't know who has sent this. Whereas we make a phone call, we send an SMS, we know who's the originator of this one. So when it comes to anonymity, a lot of these intermediaries are using privacy as a main argument, that we want to give privacy to the users so that they are not revealed. So how do you think that argument is valid here? Because if you remove anonymity, and if you look at Awkward, which was launched, where you would even see who's visiting my profile, who's accessing it, who's doing what. But that level of anonymity is kind of being misused, in my opinion. So what do you think could be done? And with IPv6 coming in, why not every citizen have an IP address which is linked to his Aadhaar, so you know who's doing what?
Yeah. So any other questions?
Brilliant question for Nikhil.
We'll take a few more questions. Anybody else who would like to pose a question?
Hi, I'm Nikhil Narendran from Trilegal. So based on the information which is available, and there are a lot of studies which sort of points to this, political parties tends to be the largest producers of fake news or misinformation on the platform. So we are looking to regulate the intermediaries, which is a fair idea. We can definitely talk and come to a conclusion, but the question is, what is the role that political parties should be taking on? Do we really need to look at their responsibility under the election laws, or so to speak, which sort of gives them a bit more responsibility because they seem to be producing the large amounts of it? That's specifically to
Anybody else? Any other questions? Yes, please.
Hi, I'm Richa from Amarchand.
You're Richa from?
Amarchand, Delhi office. I had a question for Charles. So Charles, you discussed the Canadian Supreme Court judgment whereby the Supreme Court ordered Google to globally take down a particular content. But as I understand from the discussion that the judgment was rendered in IP context, do you think the same standards should apply for, let's say, a subject matter such as defamation, where different countries will have different standards of defamation? So basically the issue of geo-blocking versus global takedown. Where do you think, where do you think the balance can be struck between a subject matter such as IP and defamation.
So I'll just request anonymity, political parties, defamation. So Nikhil.
So actually, her point, there's an answer in what you just said about different laws in different countries. So think about anonymity from that perspective. There are countries where, for example, homosexuality is illegal, and anonymity allows vulnerable communities like that to speak up and advocate for freedoms for themselves in those countries. So there is a bad side to anonymity. There's a good side to it, and different regimes will deal with anonymity differently, because there might be people who are trying to do the right thing that can get harmed because they don't have the protection of anonymity. There's no right answer to that particular question. What I'm saying is that when there is, in a particular country, when there is something that's illegal that's done, I would question whether law enforcement authorities are doing all that they can using, for example, traditional police work to be able to identify particular individuals. That's not to say that platforms themselves should not change in order to be in a position to identify individuals when a lawful process is followed in that country. So, for example, if, and there's a debate going on whether breaking end-to-end encryption, can you identify people without breaking end-to-end encryption? And I believe that you can. That the platform now needs to essentially evolve to enable that. And there can be a process that's followed to allow them to do that. They don't want to do it. So, my point is that anonymity isn't a problem in all circumstances. It needs to be protected as well. But when there's a lawful order from a court, so one of the things that I'm most worried about is enabling mass surveillance and mass collection of data by governments, and not just our government, by any government, through the same process of breaking anonymity, collecting data. And we've heard of rules that are coming in for vast amounts of data collection. Governments are also today seeing the power that data collection brings to corporations. They're trying to get the same power for themselves by data collection. That's a completely different debate, but I wouldn't compromise anonymity at this point in time.
Time's up. So Nikhil's question that...
I'll be quick about it. There's this perception that there are a whole bunch of evil old men sitting together in a room, conniving on how we're going to make sure that we're in power forever. And take it from me, I sit in that room, and that's not the conversation that happens. Unlike with people that have professions, with politicians, yes, it is important to be re-elected. But there's this very rustic saying, "Jaise praja, vaise neta," and we don't.
Translate that for...
your politician is just a reflection of the people or citizens, and.
The word is raja, not neta.
So we don't shirk away from our responsibility. And in fact, we try and, it's something that most people don't believe. We actually do not encourage these sort of activities. A lot of third-party organizations, a lot of other organizations that just because someone wears saffron is linked to my party, but is not. Right? Yesterday, somebody pointed a gun at Mahatma Gandhi and said some nonsense, linked it to our party, which is not. It's completely independent. But those are things that happen independent. Those are not things that are pushed down by a political party. If you look at the official handles of the BJP and the youth wing, those are things that we do. To very briefly touch upon it, the party is very clear that we want to stand on the body of our work, which is why we make creatives and other documents on the statistics of the work that we've done. And for the youth wing, we try and entertain people as much. I personally believe I really like the work of Andy Warhol, so I try to use memes as much as I can,
but
culture
the
to do it.
question is that should we, through law, regulate the political parties rather than going after the intermediaries? Because they seem to be, as he said, many studies that they are the biggest purveyor of fake news.
So empirical, right? There's nothing, it's empirical studies, it's nothing.
Regulation, would you mind that regulation?
So it would be hypocritical for me to say no, right?
I don't know. It's a free country so far.
So I'll conclude by saying it would be hypocritical for me to say no.
And the last question, the defamation libel laws.
So very, very quickly, I just wanted to make a distinction that's important. In the Google decision, it wasn't about notice and takedown. So they didn't take down the content that was illegal. They couldn't. What they did was they didn't, the search results didn't produce, it was more about the right to be forgotten sort of thing. In other words, they just didn't produce search results that would lead you to the offensive content. So that's the first point. So in a defamation case, if it were to be treated in the same way, it wouldn't be about taking down the defamatory content. It would be about blocking access when a search result is taken in a given country to the defamatory content. So the second point that I would make is that each type of illegal content, if you will, has its own treatment in law. The rules that are associated with, whether and when you can block access to certain types of illegal content vary. Is it hate speech? Is it an IP violation? Is it defamation? The legal framework is going to vary. And defamation typically happens in a location because it has an impact on one's reputation within a location. So you don't have, I think to a certain extent, the issue of the standards of defamation differ all around the world. Well, that's true, but I'm kind of defamed in Canada because my reputation is being affected in Canada. I'm not being defamed in every single country in the world, if you see what I mean. So I think it's perhaps less of a problem from that perspective. Just very quickly, I would mention that in the same parliamentary committee recently in Canada that was looking at the threat to democracy imposed by misinformation. 2 points that were recommended, 2 recommendations that haven't yet been implemented, but at least they're on the table. One is, goes to the issue of transparency, so that there's consideration that political parties would have to be transparent about the fact that, in a sense, the story that doesn't sound like a political ad is a political ad. And so that would have to be, I forget there was a second point, but I'll stop because time's up.
So thank you, and just in my closing remarks, I'll say this. For many years, whenever in my low moments as a journalist, I go back to what is called the Pentagon Papers judgment, which was delivered by the Supreme Court, the United States Supreme Court, and by a majority of 6-3 ruled and upheld the First Amendment to the United States Constitution, the right to free press, and why we need free press. So the essential point is that these are issues which are fundamental to the way we live and the way we do business and the way we exercise our rights. And if you don't find answers to these questions, then we will fundamentally end up harming the way we want to live or the way we are currently living. With that, thank you to my panelists and thank you, audience.
Oh, it's his mic.
The post.
Yeah, so I think to refer to what Saikat just said, you should, if you haven't seen the movie The Post, you should definitely check that out. It's probably one of the better movies about journalism and the right to speech, and I think Washington Post was it, right? So it's a fantastic movie. You should definitely check that out. Thank you very much, Saikat. Thank you very much, panelists. There's a small token of